There's nothing. It's the court sound is off. The courtroom is muted. Right, make me part of the courtroom up here. Oh, so Eric Rose says, did you see the Slim So and Woody videos where he's on a rampage throughout ATL, where he's driving around in the Hellcat? I watched that. He was like, "You ready?" And the other guy did not look ready.
Speak, and I will follow the court's instruction.
Thank you.
I think we can very well go ahead and I can put an email together that outlines what we have agreed to in terms of the redactions. There is one portion that we checking the transcript of that, and also just talking. We can go ahead and resolve that. We don't have to do that right now.
That sounds good. All right, so, and you can just file, I mean, it doesn't have to be in email form. You can just print out, here's what we've agreed to and file that.
I'll do that.
All right, so what's our next statement we're moving to? Apparently. Mr. Adams got the easy part. Wow.
So we have it on the 21st,
January 21st?
February 21st, 2015.
Okay, right. We've got January 11th, January 28th, February 20th, February 21st, and June 10th, right?
Right,
So this is February 21st.
yes.
All right, let me get that transcript and y'all can switch to that video to the extent
We're
we
moving
might
on
need
to another
ever
interview.
watch a portion of that video. Okay.
Come on, Shard.
Your Honor, and I apologize. Okay. All right, so for the February 21st statement, what's our first portion we need to look at?
For February 21st, first thing I have is page 13, line 19, page 14, line 3.
Okay.
Do you have?
And Doug has seen the Tootsie Pop animation that Flesh of the Gods made. He said it's pretty funny.
And Your Honor, what I'm gonna try to do to get this moving a little bit, I have a, transcript provided yesterday by the court,
Okay.
regarding my prior arguments about some of these issues, and I'm just gonna try to come up with the transcript and reiterate what I've argued in the past. So it should say it.
Okay.
And you have the transcript.
I do. So let me pull that up. Can you tell me what date?
February 21st.
No, I'm sorry. The date of the transcript for this trial where the February 21st statement by Copeland is argued.
It is June 21st.
Okay.
2020.
All right. I have that up as well.
Okay, so if I seem to be arguing something that's not consistent with the transcript, please just let me know it's not intentional. It's just I got too many transcripts going on. But my understanding of what we're talking about here is Investigator Gaither is prodding Mr. Copeland for information about who shot at him. And in this context, it is the February, I believe it's February 19th or 20th shooting that they're prodding information about and asking Mr. Copeland to tell them who shot at him and his child and
Right.
his mother of the child. And Investigator Gaither goes through an extended, I'm not going to say monologue because it is broken up, but she is attempting to extract information from Mr. Copeland, and she's talking about the need to protect the community, to keep babies safe,
Mhm.
and just essentially makes an argument in that interview that would draw an objection, at least for me, if the state were to make the argument in closing arguments. So I don't believe, I think, the focus, if we're admitting these statements in part, if they are admitted, they would be because they're inconsistent statements by Mr. Copeland.
Mhm.
And I don't know how that somehow opens the door to Investigator Gaither to give basically her, thesis on why her job is important and gangs are bad and the community needs to be kept safe by her and her co-workers. So that's our objection, 403, 401. And it doesn't fall under prior inconsistent statements.
Come on, state, what's your counter?
Okay, I'll hear from the state.
So previously, Your Honor, when Mr. Copeland was here in court, his testimony in court was essentially, and I'm going to paraphrase, I didn't care about snitching. I didn't care about telling on police. I didn't care about telling the police who did the crime back in 2015. And so this portion of the interview was in contradiction to what he was saying on the stand, because in these 2015 interviews, especially early on, January and February, he would not tell the police who shot at him and his child. And so this portion of the transcript, he's explaining, if I tell you, you can't protect me, you can't do anything. And so Detective Gaither is having a conversation with him about some of his concerns, because this interview, Your Honor, is immediately the day after his first interview regarding this shooting. So he's interviewed on February 20th. And then either in the morning hours or late at night, he's arrested on a probation violation. And then he's brought back in
Conveniently.
again to further, they're trying to find out who shot at him and his children. And he has extreme concern about telling the police who shot him, actually admitting to that. And when we were in court, his testimony in contradiction to that was, one, that the individual that he eventually says shot him didn't shoot him. He says that in court. And then he also says that he wasn't concerned about snitching.
Meaning I didn't have any problem with that. I was happy to tell them what happened.
Yes. And so
if he testifies consistently to that, or if y'all decide that you're going to stipulate to any part of the testimony, then this would become relevant as a prior inconsistent statement.
yes, Your Honor.
Okay. All right. But that wasn't the objection from Mr. Sharp.
Sure
So
wasn't.
even in going to I give that context because their conversation here is the effect on him, what she's trying to tell him in order to get him to actually tell her who's the person who shot him.
Right.
So we're not really worried about her. We're not offering her commentary for the truth of the matter asserted,
Right.
but we're offering it for her, what she's saying, the effect that it
His-
has on him in order for him to come forward and finally
Okay.
tell who
Okay.
shot at him.
Mr. Sharp, I'll give you the last word.
Well, I mean, I understand the state's argument, but I don't think necessarily the need to provide context opens up the door to, investigators just going in long.
Okay, well, I mean, it may be that there are other portions of this that we're gonna take up. Right now, I'm looking at 13 line 19 through 22. And then basically 14 lines 1 through 3, where she's saying essentially, hey buddy, you gotta tell us what's going on, which is pretty much the beginning of any conversation, interview, interrogation between the police and anybody. And it shows that Mr. Copeland is very hesitant to do that. And so if he ends up testifying, man, I don't have any problem with that, then this, I would think, can appropriately come in as a prior inconsistent statement. I don't see any real other kind of like 403 or anything issues with it. So this is in, assuming obviously the foundation for getting it in as a prior inconsistent statement is laid.
So the next portion, Your Honor, is page 25, line 15 through page 26, line 3,
Okay.
timestamp 40840 to 40940.
And Your Honor, last time we discussed these, this one, the one we just discussed, the one we're just about to discuss now, and the next one, we discussed all together because they're the same issue.
Okay, well, I'll look.
And you, I think you'll see, I hope you'll see that that Gaither says more and more, investigator
Okay.
Gaither says more and more. They're all the same.
Oh, all right.
I'm confused on the scope of what she said. If there's foundation laid, so it's kind of a win for the state, but only if foundation's laid. It's just a statement where it could show a hesitancy on Copeland's part to speak to the police. But he testifies that he buys time at first to think of something to say.
So y'all said
So is that
26
inconsistent?
line 3?
So they might
page-
struggle with
starting at page
foundation.
25,
Right, line 15 through 26, line 3?
Yeah, it's probably more like line 7.
Yeah, okay. That's what I thought.
They might struggle to lay foundation for that when the time comes.
This one looks okay also to me. Then. I mean, she doesn't seem to be saying we're the heroes. She seems to just be saying, God, tell me something if you want it investigated. All right, what's the next one?
Page 28, line 7 through 14.
Okay.
I'm sorry, the time is 4:10:55 to 4:11:05.
Any additional argument, Mr. Shard, on this?
I mean, it's the same thing, it's just, we care about, the life of children and those sort of things. And, we're trying to put an end to all this, we find that prejudicial.
All right. Any response from the state?
Yeah, I think it's the same thing. She's just trying to get him to tell her who is the person who shot at you? And
All right, now, if she ends up standing up in closing and starts saying, look at how great the police are, they love this guy's baby, then we'll have a different issue. But just as a part of the interrogation technique going through a statement, I'm gonna overrule that objection.
the next, Your Honor, is page 29, line 9 through, I think I might have I have page 48, line 11, but I think that's a course indulgence. Didn't do this, so. Okay, I think it's page 29, line 9 through page 30, line 18.
All right, and what's our issue with this? Is this the same concept, or is this moving on to some other evidentiary issue?
Yes. And I believe that Mr. Shar wanted it out initially.
Any questions?
Yeah, this would be easier if we could hear them like read the statement that they were looking at, but they're not reading it out loud.
This is more side conversation that is, at this point, I don't believe, well, I know our stance is that just because if the state successfully lays the foundation for specific prior inconsistent statements, our stance, my stance, I believe I stand for everyone, speak for everyone here, is that if prior inconsistent statements are included on a tape, that does not necessarily mean that the state just gets to play the tape. What they play still has to be linked to prior inconsistent statements.
Okay,
And here, we're just kind of going and talking about things that are not subject to these prior inconsistent statements. Of course, I don't know what the prior inconsistent statement is right now,
right,
but I think that there's a lot of fluff in between.
right. Okay, and is the state proposing to, I've got a prior inconsistent statement somewhere in this 30-minute interview. I'm gonna play the whole interview, or are y'all happy?
So the state's position, again, depending on what we, I think that's what we talked about yesterday. What he says is, I spoke to the police, everything I said, but it was all a lie. I so read up line by line because his general statement here in court is, I may have said everything that you said, I said, but I was only saying everything that I said because I was trying to get out of going to jail, because I was trying to get out of getting in trouble. I was trying to get out of trouble. We believe a Scudder case going, I think it's Scudder, I'm citing the wrong case, going line by line, but specifically as it relates to this portion, we asked him about being a snitch, and this is her trying to explain to him, you need to tell us. It doesn't matter if you're a snitch or not. You need to come forward. When in court, he says something opposite. He says,
I don't know what I said before, but if it was a lie, then you can't necessarily just play everything he said. But if he says, everything I said was a lie and I just said it to get out of jail, and then you say, aha, this shows right here, you were willing to go to jail and keep quiet, then if
That'd
we
be
assume
interesting
he
on
says
cross.
that on the stage.
What are you interesting to go to jail for?
But it has to be like every line, but you can't play an hour-long, most of that video
They already
in some
did.
way is inconsistent to what he's saying on the stand. So I mean, this is pretty theoretical right now.
I think you just need to see what he says. While well, there's a lot of people. Talk about stuff. They were trying to force me to do these things, and that's inconsistent.
That would be,
So
this would show that's not true. Okay, so yes, potentially then, I mean, obviously for all of this, to make sure that y'all don't operate under a theory that something in this, and I'm just making it up, I don't know how long the video is, but 30-minute video is an statement. Y'all know that.
No.
So.
You're trying to get
Yeah. So then, assuming that, I guess we don't have an answer to that right now, but I would
course we
not
don't.
think the entirety of something can come in just because one sentence in it is inconsistent. So for y'all's edification, that would probably be my position. However, assuming he uses prior and consistent statement because of whatever he says, we have to assume it for now, like that's why we're going through this. Then what other evidentiary objection do you have to it?
Well, I mean, I just keep going back to the same question, which is if the purpose. My problem is all the talking that's, Mr. Copeland isn't really saying anything. It's all investigator gate, and I just don't really understand how we're just giving investigator, and I know Copeland says something, so I'm not trying to mislead the court about transcript. You have the transcript, but I don't know how we're giving basically Detective Gaither the mic when the purpose is to be impeaching Mr. Copeland with his prior words.
Okay. Well, I mean, I think we got to have the context of what questions he's answering or relating.
To the extent that other people's words may give context.
So, I mean, I would think there aren't other evidentiary issues that would keep this particular part out, 29-9 through 30-18. All right.
.30 minutes long.
Oh, I'm sorry. The next section. Seven, line 9 through page 48.
Well, so everything we just heard, you guys, the state was going pretty much line by line with the beginning of one call. And she's like, I don't see a problem with this. It's just kind of setting the stage of how an interview starts. So she's like, okay, I'll let that
Okay.
in, I'll let that in. But then she's like, wait, are you guys trying to let this whole video in? You're not going to do that. So this was a line by line, yes, we'll let that in about
All right,
sort
what's
of
our issue?
irrelevant things. But then she said, state, I see what you're doing here, and that's not what we're going to do. So after lunch so far, not really a win either way, in my opinion.
Okay.
I think it,
She just said she's fine.
You're gonna get hit, and it's gonna hurt.
Rough and tough monsters of the Midway. This is your team.
Unequivocally, we have the right set of individuals. That's what we do.
They're gonna take us to the next level.
Hard Knocks training camp with the Chicago Bears. Streaming exclusively on Max.
And then positive masculinity, thank you for the 5. This is like so true. The jury has already heard hours of these videos, and they're going to be instructed to disregard certain things. But some of this footage, it sounds like they're going to see twice, especially the first video that they had played for the jury. So that seems prejudicial to have them repeat a video unless they're asking, unless they're requesting to see it again. How do you reconcile that?
Okay.
It's going to come down to foundation when Woody's back on the stand, you guys. She's not saying, a lot of the time she specified with proper foundation. And now she explicitly stated to the state, you're not going to just play the whole video for one prior inconsistent statement. It has to be laid that there is an
Any memory
inconsistent
about
statement
why this was objectionable?
for a part to come in.
I think it may be that were used that was confusing. I'm looking at the transcript.
Yes, on the screen right now, Biliano's bringing a Thugger Daily tweet that Judge Whitaker's basically giving Woody an instruction manual on how to testify to make sure his interviews are inadmissible. He technically shouldn't be watching the proceedings, but
Y'all. Anybody know?
It was, okay. It it was, I think it's likely to confuse the jurors. This is a very poor transcript, but essentially, and you can't really tell from reading the transcript, my understanding is, Investigator Gaither is asking, when's the last time that Shannon and Demekion were hanging out together? And when it comes down to it, the answer is, his answer, it comes down on page 65, line 5. It says, since they shot at their car. And when I hear that, in that context, it seems that he's referring to
They as in Shannon and.
Shannon as shooting at a car. I believe what Mr. Copeland meant by that is it was an incident where they were all shot at. But I just have a problem with this being played and putting that perception in the jurors' mind.
Okay. All right, and is there a redaction that could be made? So what is it that you potentially want this for?
If it comes in, it gives a lot of context. So Mr. Copeland, in this interview, this is now his third interview that he's had with APD, his second with Detective Gaither. So, excuse me, this is his fourth interview, and I'm saying this in context. In the January 28th interview, he talked to Detective Gaither about the shooting in the car with Demekion and Shannon with him. So when he's discussing right now in February that the only people he hangs out with is Little D and Shannon, and that the last time that he's really seen them is since they shot at the car, that's going back to what he's already talked to Detective Gaither.
All right, in this particular interview, have he and Detective Gaither just been talking about that particular shooting where the three of them were the ones who got shot at?
He's talking about collectively everything that's been happening since January 10th.
So know them. Like if you're the jury listening to it, you might be confused when it says they shot at that car.
But this is the only car incident that when you look at all the interviews.
All right, hang on. So y'all have alleged, I don't know how many different acts in furtherance of a conspiracy, and you've got 8 or 9 different incidents, I'm sure some of them involving cars, where people are getting shot. So it is entirely possible if they hear this, that they, the jury, will be confused into thinking, here's Mr. Copeland saying Shannon and Mr. Garlington are out shooting at a car. And that would not be fair to the defense. So is there a way that maybe we can redact out that little part about they shot at the car, since nobody knows who the theys are if you don't listen to the whole 4 interviews in their entirety to know the context of it, so that we don't confuse the jury? Yes, there is a way to do that, is your answer.
Yeah.
Later on in his answer, you're saying, I don't need the house anymore, I
Yeah.
stay away, so I don't think that confusing sentence really
Adds anything to it.
Yes, there's a way we can redact this, Your Honor.
So y'all could just redact out that part.
Yes.
All right. So that is 65 line, is that 65? Yeah, 65 line 5, the part that says since they shot at the car. So the rest of it's fine, right? Is the rest of it's fine, Mr. Sharp, essentially?
Yes.
Okay, next.
The next part we have, Your Honor, is page 155, line 1 through page 156, line 2.
Okay.
And then while the state is getting their life together, thank you so much. What's up, Bree, for the 1999? Bree says, hey, Kat, quiet watcher until now. I know that. I do that a lot too. Love how you're breaking this case down. What do you think the best response for Woody to give on the stand now? Can these tapes be avoided without YSL being snitched on? I mean, the problem is as soon as cross happens, I think if we get to cross, as soon as cross happens, I think the defense has so much ammo to work with. You know, did you meet with them? How many times did you meet with someone from the state before your testimony in June? Did you meet with them again before you took the stand again in August? And all these questions are going to come in. Did they help you understand that you can answer I don't recall? Did they try to nudge you or encourage you that you should answer certain questions that we ask you? Did they give you an alternative to what could happen if you don't answer certain questions a certain way? Because what that will show is the state trying to strategize on how to force foundation being laid, even if that foundation being laid isn't Woody testifying truthfully. You see in the June 10th ex parte transcripts, Hilton specifically discuss impeachment. So it's already in her mind, prior inconsistent statements and impeachment by contradiction. She's already looking for her two avenues the whole time she's speaking in these ex parte meetings.
Argument.
Of course, the state's not ready though. That's okay. It gives me time to chat with Bree. But I think Woody going up there could be the same thing. I don't recall. I was just buying time. At the very beginning of the interview, I would try to feel them out, figure something out, tell them a little bit of a truth. That way they believe the next thing I would tell them. And as soon as I figured out what I could say that I could get out of there if I tell them this thing, tell them what they want to hear, figure out what they want to know, and then I say that.
The issue, Your Honor, is
it's not a contradiction.
So,
it's consistent, if you ask me.
There's a shooting at a gambling house where by this time, Mr. Copeland has determined that an individual by the name of Kelvin Watts, as well as some of his friends, I guess, were responsible. And I think Mr. Copeland was allegedly shot out. I think Mr. Williams was allegedly shot at or present in the gambling house. Maybe some other individuals as well. Mr. Copeland tells a story, and it's tough to really grasp from the transcript, but no one knew who did, according to Mr. Copeland, no one knew who did this shoot. It was supposedly, and everyone thought it was another group called NBC who had jumped Demekion Garlington on that same day at a club somewhere. So the thought was NBC was responsible for shooting the gambling house. Now, by this time on the interview, Mr. Copeland has determined it was Kelvin Watts. How did he determine it was Kelvin Watts? What's his basis? Okay. Well, Kelvin Watts was apparently dating a lady named Trevia, who Mr. Sledge also dated. So the flow of information, as I understand it, is Kelvin Watts, according to Mr. Copeland, Kelvin Watts tells Trevia that he was responsible for shooting up the gambling house. Then Trevia tells Mr. Sledge, and then Mr. Sledge tells Mr. Copeland. So these are not observations based on Mr. Copeland's firsthand knowledge. These are, it's like game of telephone at this point. And he was under the impression that it was NBC based on speculation. So, you know, if Mr. Copeland gets on the stand and starts talking about what he saw at the gambling house that night, that's one thing. My understanding he was there, but to say he did it and all the rest is just layer and layer of hearsay. And then on top of that, he's talking about Mr. Garlington being jumped at the club by NBC, and my understanding is Mr. Copeland was at the gambling house and not at the club, so I don't know what his basis of knowledge on that is either. So he's talking about two different things that he doesn't know.
Okay.
So I'm not sure if the shark said he doesn't know about the shooting. He does know about the shooting because he was present at the shooting. So the shooting.
Right,
Shooting.
for that, it's who's responsible for it might be hearsay on hearsay on hearsay. What do you say to that?
Well, what he says here now is that Gucci, he found out from one person, which was Gucci Red, and that is not Antrevia Smith. That's two different people. Gucci Red and Antrevia are two different people.
Okay, so
So-
where's the part where he says, here's who I knew it from?
So if you go to page 156,
Uh-huh.
round, it says unintelligible, so you need to hear it. But it says Gucci Red. I can play that portion for
Please
you.
play it. I want to hear it.
What, give me a
So
line number.
Line 17.
Okay.
And if we skip to line 15, says, "Goddamn, the next night we at the gambling house. They ain't put no picture. We in there gambling. They taking pictures and shit. Then they came up and shot at us. Only reason we found out it was Kel. He had got into it with Gucci Red. And then she talked to them and she came back and told us, like, man, that was Kel and them that shot y'all. Make it seem like they did because they shot it up.
Okay.
And then they went and shot at another spot. And then Monday we got into it with NBC. And then he goes on to talk about whatever happened between them and NBC. So whether or not Gucci Red told them that Kel shot at them is irrelevant, because what this incident at the gambling house does is kind of form the basis of other events that happen after the gambling house. So some key incidents early on in this conflict between YFN and YSL is there's the gambling house shooting, and that becomes important because after the shooting, I believe it's the next week or the next day at Cascade Skating Ring, Kel, who's the person who shoots at them, and Mr. Williams have a phone call in the presence of Copeland, in which Mr. Williams wants Kel to pay for his car window. So this, whether or not Gucci Red told him doesn't matter. It's what happens afterwards, which is the impetus for this conversation about paying for the car that was shot up at the gambling house.
Well, it could just be because your window's broken. You find out that your window's broken.
Okay.
I mean, in other parts in the discovery, it's the flow of information is described as different, but either way, if it comes from Gucci Red, it's still.
You're saying they're not offering it for the truth. Right?
After it derives from them knowing that it was Kel who shot at.
All right, so if that's the only objection, then I'm gonna overrule that objection.
State wins.
Okay.
And then thank you to Dylan Doherty. Do you think the state knows that they're losing, so they're going to drag this as much as possible? I think they're
173,
confident.
Line 7 through page.
They didn't even want a mistrial without prejudice to retry. And then thanks for the compliment also. And also Case Cooper, a new member, and Jen.
Okay. All right, Mr. Sharp, you want to articulate your argument?
And Ms. Hilton, you said it ended at 174 too?
Yes, sir.
Just trying we'll withdraw that.
All right.
Yeah, next is page 181, line 8 through 12.
All right. Can,
And
any
we didn't-
chance we can just get rid of that?
Yeah. we have
Okay.
an objection to that.
There we go.
Hey, where
And
are we going?
the last one we have is page 185, line 17 through page 186, line 19.
The last one for February 21st.
And you're right, we're okay with redacting.
Entirely? Just trying to get clear what you're saying there.
Yes.
Okay, so that'll be 185, line 17 through 186, line 19 will be out by agreement. Okay? What's our next portion of this transcript?
That's the
That was it.
conclusion that we have.
Oh, okay, well. Okay.
We're done. We
What's
got
our next
one call
statement
done.
we're moving to.
We can do February 20th.
Okay,
This was the day before.
Same transcript there.
Guys, there's still foundation that needs to be laid for a lot of this. It's just not outwardly excluded.
and is there an associated trial transcript where y'all are arguing this that might be beneficial to look at? I mean, we didn't end up using that other one very much, but
Might need to define foundation for the state.
I mean, if you're not even using it, then that's fine.
Well, I'm trying to remember. I haven't seen a transcript. of it.
Okay.
And February 20th may have been earlier before the break.
We
Oh,
don't-
well, hey, then, we don't need to rehash that one.
And that's, I'm trying to figure out, but for January 11th and February 20th, I'm trying to figure out when we had those arguments, because we actually played those videos on the.
Okay.
Started on the 12th.
We haven't received the transcript when we discussed January 11th or February 20th, so I don't have an independent recollection of what they are.
And those who had the minimal, we agreed on most of that.
Okay.
Actions that came out, we agreed on.
And they've already been played. Y'all just aren't sure whether it was pre or post recusal motion. Is that what you're saying?
Yes, those two videos were played. So the record's clear.
Before.
The video for January 11th and the video for February 20th were both played in front of the jury.
So
At least on the 14th, and I believe on the 17th of June.
Okay, but,
I assume that the argument may have happened,
okay.
I don't know if the argument happened post the 12th.
Right.
I can't recall, or if it happened pre the 12th. That's what I
There's a logistics issue there because are you going to have them watch the same video footage twice?
Okay.
I have that the June 11th interview, excuse me, thank you, January 11th interview was played on the 17th. And the February 20th interview was played on the 17th. So those were played after the motion. I just want to make sure. What does this mean? Okay. It looks like portions of the January 11th were played before. A very small portion, like 30 seconds of it.
Was played before what?
Most of the
Okay. So would that indicate to y'all that y'all had already hashed out the evidentiary issues with regard to the January 11th?
They kind of rushed
statement
into that.
prior to
'cause
the
they had
motion
nothing else to
recuse being
do.
filed? It would indicate that to me, but
Um,
did you at least do the entirety of this January 11th statement at the same time? By which I mean, that was not at all clear. Did you handle the evidentiary issues with the January 11th transcript all at the same time?
I knew what you were asking. I don't know the answer to it, and this is why, because
Okay.
and this matches my recollection. This Hilton used January 11th was one very particular point that she played like 30 seconds
Right.
to Mr. Copeland. So I don't know if we had reviewed the whole, and she also played a 10-second clip of the January 28th interview before the motion to recuse.
All right.
And a 12-second clip of the February 20th. But I'm trying to see if there's any note about when we discussed the actions.
So I know that after the jury leaves and hasn't yet come back, y'all discussed the January 21st and the February 21st one. So y'all had not done those pre-interview. I'm not helping, am I? I'm making it more. Okay, yeah, no, I don't know what that means. February 21st. I don't know. So if y'all don't know whether you dealt with all of January 11th at the same time or not.
So, Your Honor, initially, I impeached Mr. Copeland as the issue or the topic came
Right.
up. Then when it turned to everything's a lie, then we went to
Okay.
getting in the entire statement.
Okay.
The video, not statement.
Or playing the entire statement. And so when we had argument,
All right, so you spent a lot of time after the
Madam Mayor,
yes, yes.
Let's hear it.
Votes for 6/17/24. We sent redactions regarding. We were discussing redactions, I think, on 17th, regarding January 11th, January 28th, February 20th,
Mhm.
February 21 interviews. That leads me to believe that these were not redacted prior to the 12th.
Okay. Well, y'all said y'all are close on those anyway, so why don't we just,
so I think
if it's me revisiting and ruling differently, then maybe lucky state, maybe lucky defense, who knows? I don't know.
so I think the next video we can actually go to is January 28th, because that is where we had some more
Okay.
redactions.
So are y'all just then, as to January 11th and February 20th, y'all said, I think, that there isn't much y'all disagreed with about that anyway?
That's my recollection.
All right, so maybe y'all can get to huddle up together on those two, and maybe y'all can come to agreement. If not, you can either figure out, was the ruling made before the motion to recuse, or if there are two or three things and we don't know when the ruling was made, just bring them to me.
Yes, Sean.
Okay. Okay, so then we'll move on to February 28th. Is that what you said?
January 28th.
January 28th. Right, February 21st, January 28th. I am just making it that much more confusing. Sorry, y'all.
That is confusing.
Mr.
Especially that they
Harvey's
have one
gonna
on
use
June
that word
10th,
when I
like
say
June
that.
10th, 2015, and then June 10th ex parte.
I'm teasing you, Mr. Harvey, although I bet you will. Okay, January 28th.
Yes.
And that has either not been discussed or it was discussed post recusal motion.
Discuss post recusal.
Okay, and so do we need to look at a transcript, or Mr. Shart, you're just gonna?
If the state has a transcript of this motion, this interview.
February, January
I'd like to
28th.
work up the same.
All right, we can, I assume we have the one that ours came, I don't know where ours came from, if they came from Ms. Weaver or from the state, but Ms. Firstfield will forward you what we have. Is everybody good? Does anybody need a break? Quick break, 10-minute break. Let's come back at 3.
And I don't think anyone's going to interrupt. They've been good with not interrupting after after they pan away. So what are you guys saying? And I think we had some panic in the chat, you guys. You guys got to remember that her rulings, like this one sentence that I'm going to allow in, I'm going to overrule the objection to it. I'm going to allow it in. It's all depending on a proper foundation at the time of. But what Judge Whitaker seemed to realize as time was going on, hold on, you're giving me line by line. So there are some things that you've agreed upon, but then the things you don't agree are every other missing line. Which means if I start ruling in, you're going to ask me to play this entire video. And the point of this isn't to let the jury sit here and just watch hours and hours of video. It's what's pertinent. What's the purpose of it? What does it show that helps the jury have a better understanding of what is happening. And that's why you kind of see her like, all right, let's move on with this June 10th call, the June 10th call, and get on with that, because what you're not going to do is bring in the whole thing. All subject to foundation. And here's the other separate consideration. If Woody were to plead has this not still wants to plead, if this judge says, okay, I'm going to hold you in contempt for the duration of this trial or until you're willing to come testify. She's already said she only wants this trial to last 30 weeks. Woody indicated, if you look at that June 10th transcript, it seemed like he would have been okay sitting through the duration of the trial, but he didn't want to commit. He wasn't willing to commit to sitting for the duration of this trial and the trial for the remaining co-defendants that are not enjoined in this case. Willing to sue 30 weeks. Or he might get up there and just say Woody things. Who knows? I don't think he's going to suddenly get up there and either start snitching on himself, because his concern seems to be that he has done something that he doesn't want to have to be asked a question about on the stand. He doesn't even want to be asked about something. So I do feel like he's going to try to get off that stand. It posted today, but it was available yesterday. It was on the system yesterday, but nobody had a full copy of it. Wait, what? Stop it. I didn't hear that. Today felt like 30 weeks. This is, it is 30 weeks in Fulton County, but I mean, a long crime. And yeah, I mean, they gave him immunity, but you saw how he tried to maneuver even when he had the immunity at first. And then Sabata, a trial is about arguments over admissible evidence. In order to have a case, the state, of course, has to have this. The issue before was that they had loads of ridiculous stuff before. And I'm sure you're going to continue because you probably ran out of characters. But that's really what it all comes down to. And of course, and they're going to want to try to keep out things that are garbage from the state. Things that might not look good for their clients, but not because it's truthfully something that looks bad for their clients, but something that circumstantially looks bad for their clients, but might not even really be bound to the truth as far as what they know from their clients that they're sworn in with, their tasked with representing. So of course they're going to fight to keep that out. The state is fighting to keep certain things out too that the defense wants to introduce. No, there are still motions for mistrial pending, like Doug Weinstein's is still outstanding, but it's just been deferred. There hasn't been a ruling on it. We're going through all these evidentiary things today instead. Oh, and Johanna, maybe it's Johanna, all the way from Ireland. That's awesome. You've been watching from the start of this trial. You poor thing. That's so much time. Think about it. This is a long haul case. And yeah, what do you guys think about these YouTube videos? I know you guys were talking about the Hellcat video, right? So Woody, and I forgot that part when we talked about it a little bit earlier, but Woody did say at one point in the video, I'm in op territory. So I'm in this territory where people, if I was scared of somebody, I'm in their neighborhood. Like, so is he scared of people? I think the defense is going to, if they need to, argue that all this stuff going on with his cooperation to testify, all of his meetings with somebody from the state, those private meetings with Hilton, where they're talking about great things, life stuff, building rapport. The state can ask about all that. The state can ask about all of it, and the jury can determine what they want to make of it. And yeah, they can keep applying for a mistrial. I mean, we've seen how many have been tried for already in this case. Certainly not a shortage of attempts to call for a mistrial. Yeah, and this one's huge too. Seeing that Doug is a nice person. Like, and yeah, it's just so, there's a lot of things in these interviews. There's a lot of things on his text posts on his Instagram story. And it would be really interesting to watch the state fight to keep that stuff out because they've fought so hard to bring in social media posts. So just watching them make the counter argument, which is their job to counter, it's their job to argue for certain things to come in and their job to argue for certain things not to come in. But just saying, on its face, it would be interesting to see them oppose the same thing that they wanted so badly. But if that thing, those social media posts now have something in them that look bad for them, they're going to be like, no, it's just social media posts. They shouldn't come in. How is that, probative? We don't even know if it was Woody on his own account. And we're going to see all those arguments made. Wait, was this in the Hellcat video? A girl said free thug and he said for show. And not for nothing, but if the state wanted to, say Copeland was good for the defense, the state would then, I'm sure they would, say Woody was the defense's witness. The state didn't need him to lay foundation for all these videos that they want to bring in. The state would surely bring this up and want to get this statement in. Oh, but he's on social media as a sworn-in witness saying free thug. So we need to let the jury know because they could use that to weigh the credibility of what he's saying. But, the state doesn't want to argue anything that would discredit Woody because they at least need live. Okay, so TikTok live. Yelling free YSL. Like, come on. Like, that's just crazy. Technically sworn in. Technically sworn in. I can't wait. She keeps kicking the can on these logistics conversations about how we're going to deal with Kenneth Copeland getting back on the stand. Like, I know we're going through the videos that are supposed to be played while he's on the stand. But as far as speaking to the jury, how much of his testimony are they supposed to forget? Like, I still feel like we're going to see Bruce Harvey get up and make arguments during those logistics conversations. As soon as we're back on topic, Harvey's going to be like, look, it's just impossible. It's noble that you're trying, but there's just no light at the end of the tunnel for this attempt. It's futile. To Boston. And also, we did get this written order. We're not going to disqualify Love and Hilton. But the basis for that was we had other evidence available, possible other witnesses. We have the transcript. So I still don't think we have a decision on a proffer regarding Melnick. Because Brian Steele said, I've got the subpoena and he's here. I'm sure Melnick is pretty all right with coming in and speaking his piece. And he's in the courtroom, so if they want to do this any day, I'm sure they can pull him. But I wonder when we're going to circle back to that. What do you think Steele's proffer about what Melnick has to say? Like, come on. No, Anthony, they need these videos for some of their witnesses that they plan to call after. I think the closest thing to physical evidence is corroborating evidence where they did find casings that match a type of gun that one of the co-defendants apparently had. But I'm not sure they have ballistics to say that they ran that gun and matched it that it came that that bullet fired out of that specific gun. Have would use in that gun. So it's circumstantial. Unless I'm wrong, I don't believe that they did a ballistics. And I agree. I agree. Yeah, and there's no report. Okay, so you guys know you're correct, Kat. They didn't run ballistics and there are no reports. And then Moses Dupree says, as somebody who fires guns, you can't make a case based on casings. For example, any 9mm round can be fired from any 9mm firearm. Or, I want a Glock. Like, you're gonna be brand loyal because of your experience and awareness of seeing other people have the same guns. So it's not unusual that someone would have the exact same one. So how do they know for sure it was just you? If they don't have reports, if they don't know where these shell casings actually came from. It's nonsense. It really is nonsense. But for the sake of admissibility, it only needs to rise to the preponderance standard. So that's why
Your Honor, can we have just
okay, it's the court audio that's quiet. I keep waiting for them, but it's them that's they've got the sound off. I think they're doing it anytime the clerk is up there speaking at the bench. We do have all 4 screens back. Where's Julie Horn? Julie, are you here in the chat? Julie, the cameras are up. I don't see Julie. Maybe she's listening. But you can see all 4 panels on the screen are lit up again. And I think unless I worked out the whole day so far today until now. Hey, Nick. Miss Love is placed furthest away from the defense since nobody wants. Showing the love to Nick in the chat. Something about like to the end of time. I think it was like a biblical reference. Yeah, Moses, that's what I've gathered, unless I've missed it. And Nick Starro, is it just casings that we have? Have any ballistics reports recovered from any individual's gun that says these shell casings were fired through this defendant's weapon? 'Cause I have that. Only casings, no guns. I do appreciate Shard and Hilton trying to use this time wisely. I mean, while they're figuring out, I don't know, tech issues or something. Yeah.
So you're on the first time that we have, we're at issue, is page 42, line 40.
Think we're talking about January 28th. Those calls, that recording. So Plain Mary Jane says, I wonder if a lawyer has ever accidentally called a judge mom like little kids do in school. I called my 5th grade teacher mom once. It was definitely a guy teacher too, Mr. Brown. I think I felt like I died for that day. I like went back to my desk like, oh no. No, not Deputy Brown.
First segment, it's a dispute. It's a discussion about possible, quote unquote, beef between Buddy J, who is, his name, last name is Usher. And he is allegedly a member of IF, or an affiliated subset of IF. And he's a rapper. And I think the state's theory in some ways is saying, and Mr. Williams, because Bloody J said some things about Mr. Williams, Jeffrey Williams. Mr. Say that Birdman Williams, Brian Williams, aka Birdman, wanted to sign Bloody J, but Jeffrey Williams didn't want Birdman to sign Bloody J because of the feud that they had between each other, and he was blocking Birdman from signing Bloody J. But so that's the background. But the bottom line is Mr. Copeland saying they said that Birdman wanted to sign Bloody J. There's absolutely no indication. My understanding is that Mr. Brian Williams is a multi-millionaire who runs a big record label. There's absolutely no indication that he signed not to Ken Copeland. And Ken Copeland just kind of, and he says it. He says they say this, they say that. And so that's all hearsay from our perspective. It's all speculation. It's not based on hearsay. And Brian Williams is on the state's witness list. So if they want to call Brian Williams and ask him about what his plans were to sign, allegedly stop him, they can certainly ask Brian Williams.
And Your Honor, the state has no objection to page 43, starting at line 4 through page 44, line 8. The only portion that the state wants in is page 42, line 3 to page 43, line 2. Talks about how he actually brought back, or he tried to get Bloody J and Mr. Williams to kind of at some point and Mr. Ussery. So when he's on page 42, when investigator Dennis asked, so what happened with Buddy J? Weren't they cool? He explains his understanding of when they may have started to fall out. Response, I think they did because Bloody J joined they gang. Whose gang? If gang is what it actually says. You know what I'm saying?